In this lecture, we'll take up hate speech, fighting words, incitement, duty of care, obscenity, and the inaptly named child pornography. Concerns about hate speech have gone on pretty much ever since the country was a country. After the Revolutionary War, persons who had supported the British Tories were criticized publicly. As history continued and the United States grew, of course, there was hate speech directed at people who were of the wrong religion, hate speech directed at immigrants, Irish, German, Italians, and of course hate speech directed at African Americans and Native Americans. About 25-30 years ago, people began to respond publicly, and there was a general move to consider the effect of hate speech upon those who had been targeted by the hateful words. Questions were raised about whether or not people could fully participate in civil society if they were being targeted with epithets, racial and ethnic. And there was a move to come up with rules and sometimes laws that would prevent people from being targeted in those ways. And criminal statutes were passed. We're going to be dealing with one particular criminal statute in the case of RAV versus St. Paul. St. Paul wanted to prevent hate speech, wanted to prevent people from being targeted by these hateful words and symbols. So the city passed an ordinance that said if you put certain objects on public or private property and you knew that the objects, which would include spray painted words and graffiti, would arouse anger, alarm, or resentment, then it would be a misdemeanor. And there was a list of objects: burning crosses, swastikas, 3Ks. Well, a black family moved into a St. Paul neighborhood, which had previously been all white, and some folks in the neighborhood were not pleased with that. They were talking about how the neighborhood was going to be ruined by the inclusion of this one black family. A couple of teenagers were listening into the conversation of the adults, and they decided to take action. So the two teens found some wood, found a coat hanger and some cloth. They used the coat hanger to form the pieces of wood into a cross. They draped the cloth over the cross, doused it with gasoline, set it into the yard of the black family, and then set it on fire. The family heard a commotion outside, looked through the window, saw the burning cross. Of course, they called the police. The burning cross, has a quite lengthy history in the South. It was an implement of intimidation, and in the South, if the Klan was having a rally and there was going to be a burning cross, you knew that somebody was going to get beaten, maybe shot, or lynched. So the burning cross is a symbol that generates considerable fear and anxiety. The two teens, being teenagers, couldn't keep their mouths shut, and they were apprehended by the police. They were put on trial. One of the teens pled guilty. The other teen, who was identified by the letters RAV because we don't identify minors in criminal cases, went to trial. And he was convicted. He appealed his conviction. There we go. Oh, the teen's name is Richard A. Victoria. He's not a teen anymore, so there's no problem with identifying him. He took his appeal all the way to the United States Supreme Court. In the Supreme Court, Justice Scalia's opinion held that the ordinance was unconstitutional. Now, the concurring opinions raised two particular points. They're both here in the bullet points. The first is that the ordinance was under-inclusive. That is to say, it didn't make the use of every objectionable symbol a crime. Because it was under-inclusive, because it only listed certain symbols or words, then it only protected certain groups. It didn't protect everybody. So it didn't include everybody who should have been protected. The concurrence also said that the ordinance was overbroad and that it criminalized even positive uses of objectionable symbols. And let me give you an example so you can understand. You may have heard about the movie Schindler's List, which is about Oskar Schindler, who saved hundreds of Jews in World War II from certain death at the hands of the Nazis. Steven Spielberg made a movie about it, very popular movie. Well, the movie features symbols of Nazism. There are swastikas on flags, there are German uniforms. The St. Paul Ordinance would make the showing of Schindler's List a crime because it would use some of the objectionable symbols, and people would know that the objectionable symbols would upset folks. So remember, we talked about overbreath in the context of Stevens versus United States, the Crush video case. We talked about it in the earlier lecture about how if you wanted to stop drunk driving, you could ban all alcohol, but then while you would eliminate the illegal use of alcohol, you would also criminalize even legal uses of alcohol. So that's what makes the ordinance overbroad. And so Mr. Victoria's conviction was overturned by the Supreme Court. We haven't had a whole lot of other cases involving the criminalization of hate speech, mostly because it is very difficult to come up with a statute that is not under-inclusive and overbroad at the same time. Well, if we don't have statutes to put people in jail, what about speech codes? Is there a speech code here at Cal Poly? I know that pretty much every university I've taught at and gone to school at, there's been a speech code. And the penalties for using particular sorts of language, words, terms, or symbols can include suspension or expulsion. And in some cases, if you're a student employee or a staff member, it can result in being fired. Well, how constitutional are these codes? We see the case of Doe versus Michigan. University of Michigan had a code that said you couldn't use certain words on campus, and if you did, you'd be subject to suspension, expulsion, and if you were a staff member or a student worker, you could be fired. The graduate assistant, and the graduate assistant's name is not Doe, John Doe, Jane Roe, those are names, pseudonyms we use in court cases when the plaintiff does not want to be publicly identified by the real name to avoid public condemnation, threats, or other problems. So the graduate assistant in the English department said that the N-word came up in classes on Huckleberry Finn. And he said if I use the N-word when I talk about some of the characters or I talk about some of the language from the time, I could be suspended, expelled, and fired. And so the federal court in Doe versus Michigan held that the Michigan speech code was not constitutional because it was under-inclusive, it only protected some groups from certain words, and it was overbroad, and that it punished even positive uses of those prohibited words. Then in the area of employment, we have Locurto versus Giuliani. Two firefighters and a police officer in New York City took part in a Labor Day parade in the borough of Queens. Their entry in the parade was a depiction of what they thought Queens would be like in 20 or 30 years. Queens had become more integrated, more black residents, more other minority residents moving into the borough, and some of the people living there were not pleased with that. So the two firefighters and the police officer made their Labor Day float. It was a flatbed truck. It was decorated with buckets of fried chicken and watermelons. The three men dressed in blackface, and one of them pretended to be a black man who had been dragged to his death behind a pickup truck in East Texas some months earlier. Well, when word of their entry into the Labor Day parade got back to City Hall, Mayor Rudy Giuliani ordered that the three be terminated. And of course, they appealed their termination. They sued the mayor and the city of New York. The district court held for the employees, but the Second Circuit Court of Appeal overturned that and confirmed the right of the city to fire the 3 employees. And the Circuit Court opinion explained, here, these 3 people, 2 in the fire department, 1 in the police department, their jobs involved working with the public contact. And so the Circuit Court of Appeals said the government here, the city of New York, may consider how the public will react to the employees' expressive acts and determine whether or not those acts would be disruptive to the delivery of government services. And so the appellate court said, these guys dress in blackface. When people hear about that, especially members of the African American community, then they may be less likely to cooperate with the police or firefighters in an emergency. They might say, well, you've behaved in a manner that is condescending. You've used this blackface. You've depicted this black man who was murdered in a lighthearted and cavalier manner. We don't want to have anything to do with you. And it was on that basis that the 3 were fired. So, when an employee on his or her own free time engages in expressive conduct, and that conduct reflects upon the government, then the government can punish that conduct for making it difficult for the government to deliver services. Now, if the 3 employees had worked in the accounting office for the city of New York, in other words, they had no contact with the public, then the city would not be justified in firing them because there would be no impact on the ability of the city to deliver services to members of the minority community. But because these were firefighters and a police officer, their jobs involved interacting with the public, and so that was the basis for firing the 3. And you can see the additional language from the court. Now, we didn't go into Hazelwood, but for law school classes, Hazelwood was a situation in which a principal was allowed to censor a high school newspaper because the content of the newspaper would disrupt the message that that the high school wanted to send to its students and their families. So, conduct or expression that disrupts the ability of the government to deliver services allows the government to punish or otherwise sanction those persons engaging in that expressive conduct. And the Circuit Court of Appeals in the Locurto case said the 2 firefighters and police officers were not being fired for dressing in blackface and making fun of African Americans. They were fired because their conduct made it more difficult for the city of New York to deliver services through its fire and police departments. There is a case out of San Diego involving a public school teacher who was a member of NAMBLA, N-A-M-B-L-A. NAMBLA is the North American Man-Boy Love Association, and the public school teacher was a member of that, an advocate for that. He didn't say anything in school. There was nothing in his conduct that suggested anything untoward was happening. But when the school district found out about his affiliation with NAMBLA, they fired him from his classroom position. The school teacher objected and appealed and then sued, and the courts there said, well, your conduct, your expression of support for this organization you belong to, it's not causing a problem where you are doing anything that is improper in the classroom, but it makes parents uncomfortable, and it makes them less likely to entrust the school district with their children. It is on the basis of that likely disruption or fear of disruption of the ability of the school district to deliver instruction to the students that justifies taking you out of a classroom position. Now, this restriction on speech also applies to things like students disrupting classes. So if we were in a classroom situation and a student was disruptive and made it difficult or impossible for a faculty member to deliver instruction, that student could be sanctioned, could be taken out of the class, could be suspended or expelled. So kind of keep that in mind. And of course, there's the reference to the teacher who was an advocate for NAMBLA. It's not that he did anything illegal, it's just that his expressive conduct made it more difficult and created the fear of a disruption of the school district to deliver service to its students and their parents. Then we come to the IOTA Chi chapter versus George Mason University. A fraternity at an annual event, public service fundraising event at the university, conducted an ugly woman contest in which members of the fraternity dressed as ugly women. Two of the members of the fraternity wore blackface and clothing that created a caricature for African American women. And the fundraiser was they had jars in front of each of the contestants, and people would come put money into each jar, and whoever got the most money was the winner of the, quote, ugly woman contest. The university was not pleased, and it sanctioned the fraternity, which then went to federal district court to overturn the punishment. In court, the fraternity established that George Mason University was engaged in a discussion about becoming more diverse. And of course, at Cal Poly, that's a topic of frequent conversation by the administration. And there were some persons on campus who said, well, if by diversity you mean bringing in less qualified minority students so that we are not quite as much of a vanilla university, well, that's going to change the nature of George Mason, and we're not sure that we want to go along with that. The fraternity argued in court that its ugly woman contest, which had African American caricatures, was a way to continue to bring up the discussion of the change on campus. The federal district judge hearing the case acknowledged that, and he said, yes, the humor is at best sophomoric and crude, and it's not particularly funny. I certainly don't find it funny, but the members of the fraternity were raising a matter of public interest. They were engaged in expressive conduct on public issues, and therefore, because of the First Amendment component, their expression was protected and the university could not punish them. And so they won their case. So, unusual behavior, perhaps racist, certainly insensitive behavior, can be protected by the First Amendment. On the other hand, we have the case of Tindle versus Caudle. Officer Tindle wears blackface to a Halloween party, and he gets a 30-day suspension for engaging in conduct that, quote, would result in justified criticism of the officer or department. Officer Tindle sues on First Amendment grounds and tries to overturn his 30-day suspension. Now, 30-day suspension means that he doesn't work for 30 days, and he also does not get paid for 30 days. The case goes to trial. He loses. He appeals to the 8th Circuit Court of Appeals. The 8th Circuit confirms the judgment of the trial court and says that Officer Tindle's blackface costume was not an expression of ideas that made up a comment on an issue of public interest. He was just dressing up to be amusing at the Halloween party. It was, as the 8th Circuit said, mere entertainment, and mere entertainment is not protected by the First Amendment from sanctions by the police department. Here again, the police department looked at his conduct and said, this will bring criticism to the department, certainly criticism to Officer Tindle. That will make it more difficult for us to deliver services to all of the community, including the minority segments, and so that justifies the sanctions that we are imposing on him. So, keep in mind, offensive speech has been protected when it's used to express an opinion about government or society, when it's used to make a comment about a matter of public concern. But offensive speech has been denied protection when it's been used as mere entertainment. And so if you are out and you see someone on campus engaging in what you think would be offensive speech, the question as to whether or not they can be punished is based upon whether they are trying to communicate an expression protected by the First Amendment, or they're just showing their fannies because it's funny. All right, let's move on. Here in the last section of part 1 of the class, we talk about the limits of constitutional protection, including fighting words, incitement, and obscenity. Fighting words. To begin with, you have to understand that fighting words is a dead doctrine. It is an evolutionary dinosaur or dodo bird. It's included in the textbook because even though it doesn't work anymore, it's never been explicitly overruled by the Supreme Court, so it's dormant, kind of like Dracula in the movies. They kill him, and years later he comes back, and again he's a big problem. So fighting words is not an active issue, but it could be in the future. Fighting words comes from the case of Czaplinski versus New Hampshire, involving Walter Czaplinski, a Jehovah's Witness, a city marshal by the name of Bowering, and an angry crowd. Now, Mr. Czaplinski went to Rochester, New Hampshire, where he was doing the Lord's work, telling people about being a Jehovah's Witness and criticizing other religions, specifically Roman Catholicism, in an effort to spread the word about Jehovah. Now, Rochester, New Hampshire is a predominantly Catholic community, and people didn't appreciate him talking about this. Now, this is back in the late 1930s, early 1940s, and people had different ideas about religion. Now, people also were doing a lot more walking. So City Marshal Bowering encountered Mr. Czaplinski when he was out handing out pamphlets and playing records of Jehovah's Witness speeches and getting people riled up. And the marshal said to Mr. Czaplinski, you know, you keep this up, somebody's going to pop you in the nose, or bad things are going to happen. You know, why don't you just go away? And then the conversation ended. Some days later, Mr. Czaplinski is on a street corner handing out his pamphlets, talking about other religions, saying that Catholicism was a racket and the Pope was a big jerk. And a crowd starts to assemble, and the people are not happy with what they're hearing. And more people show up, and the anger is evident. A city police officer, not Marshal Bowering, but a city police officer, wanders onto the scene. He sees how angry the crowd is. He sees that Mr. Czaplinski continues to say bad things about other religions. He's got an angry crowd, which could turn into a mob. He has Mr. Czaplinski, so the officer makes a strategic decision, and he takes Mr. Czaplinski down to the police station. On the way, Mr. Czaplinski and the officer encounter City Marshal Bowering. The officer tells Marshal Bowering what had happened. Marshal Bowering turns to Mr. Czaplinski and says, "I told you so." Mr. Czaplinski then responds to Marshal Bowering, calling him a racketeer, fascist, and saying the whole government of Rochester, New Hampshire are fascists or agents of fascists. Now, today, you would say, what's the big deal? But back in those days, calling somebody a racketeer or a fascist was a pretty strong set of epithets. New Hampshire had a statute, and it's reproduced on screen and in your textbook, that says that people were not permitted to address any offensive, derisive, or annoying words to any other person who's lawfully in any public place. And Mr. Czaplinski's language appeared to be derisive and offensive to City Marshal Bowering. Mr. Czaplinski was arrested, charged with that crime. He was prosecuted and convicted. Mr. Czaplinski, with the assistance of the Jehovah's Witnesses, appealed his case all the way to the Supreme Court, and the Supreme Court affirmed the conviction. Justice Murphy wrote the opinion for the court, and he started out by saying, there are some classes of speech which have never been protected by the First Amendment, and so for those classes of speech, punishment doesn't raise any constitutional issues. And in this case, Justice Murphy said fighting words were words that were not protected by the First Amendment, and he defined fighting words as those words which by their very utterance inflict injury or tend to incite an immediate breach of the peace. In other words, you say the word and somebody punches you in the nose. Now, Justice Murphy said these words are not protected by the First Amendment because they have no value. They don't contribute to discussion or debate. Their mere utterance causes harm, and the harm it causes to both the listener and the speaker who gets punched outweighs any benefits from their being said, and so they're not entitled to protection under the First Amendment. You see right there, Justice Murphy saying fighting words don't contribute to the exposition of ideas. Justice Murphy also said that other categories of speech not protected by the First Amendment because they have little or no value would be lewd and obscene speech, profane speech, libelous speech, fighting words, criminal speech. Now, you have to understand that this case is decided right in the beginning of the 1940s, and times have changed, society's changed. Lewd and obscene, well, lewd refers to mere pornography, which is protected by the First Amendment. Obscenity, of course, is not protected by the First Amendment, and when we get to that section, you'll see how we determine what is pornographic and what is obscene. Profane, well, profane is being irreverent towards sacred things, and laws against profanity are not constitutional because of the Establishment Clause. If you're going to punish someone for saying something bad about a particular sacred thing, the cross, the Torah, the Quran, well, what you're doing is you're setting up a situation in which the state is giving deference or preferential treatment to one particular religion over others, and the Establishment Clause doesn't allow us to do that. Today, when people are being profane, they're charged with disorderly conduct. It's not the speech, it is the conduct that the government wants to punish. And of course, in libel statements are protected unless plaintiffs meet a particular level of proof regarding fault. You saw a little bit of that in the introductory videos, and when we get into the libel and privacy torts in Part 2 of the class, you'll get more information about that. So, Chaplinsky versus New Hampshire back in early 1940s. Nothing happens until we have Cohen versus California. Actually, it is in the 14th edition. But Cohen versus California arises from a California statute that prohibits maliciously and willfully disturbing the peace or quiet of any neighborhood or person by offensive conduct. That's the key part of the statute you need to know. So, in 1968, during the Vietnam War, Paul Robert Cohen wears a jacket that has the sentiment Rumba the Draft on the back, only it's not Rumba, it is a four-letter word that you probably are familiar with. He goes down to a sub-courthouse in California looking for a friend who's going to make an appearance there. He's wandering through the courthouse. A police officer sees Mr. Cohen's jacket. Now, the officer is patriotic. He supports the American effort in Vietnam. He's highly offended by the statement, Rumba the Draft, and he follows Mr. Cohen through the courthouse. Mr. Cohen takes off the jacket, walks into a courtroom looking for his friend. He looks around, doesn't see him, and then starts to leave. The officer rushes up to where the judge is sitting on the bench and said, "Do you know what that guy has on the back of his jacket?" And then he tells the judge. The judge orders the officer to apprehend Mr. Cohen, and the officer arrests him in the hallway of the courthouse. He is charged with violating the California statute that you saw on the previous slide. Mr. Cohen appeals his conviction. The California Court of Appeals holds that his conduct was offensive conduct, and they explain offensive conduct is behavior which has the tendency to provoke others to acts of violence or to, in turn, disturb the peace. So Mr. Cohen gets no satisfaction from the California courts. He appeals to the United States Supreme Court. Oh, one last point. The California Court of Appeals says it's foreseeable that someone might commit a violent act as a result of Cohen's conduct in wearing the jacket. And the fact that no violence occurred is just happenstance because he was arrested before somebody punched him. So now we're up to the Supreme Court. The Supreme Court reverses the conviction, and the opinion of the court says, yes, the four-letter word that Mr. Cohen had on the jacket can be used in a personally provocative fashion. But the court says it was on the back of a jacket. He was not saying the words directly to anybody. And the court looks at the California Court of Appeals, which says, well, nobody punched him, but it was likely that he could have. And the Supreme Court opinion says, no, we disagree. I mean, nobody would likely have punched Mr. Cohen. And there's no showing that anybody who saw Mr. Cohen or his jacket was so violently aroused that punches were thrown. And so the Supreme Court looks at the same set of facts that the California Court of Appeals looks at and comes to a completely different opinion. There was no punching, therefore it wasn't a fighting word. Then Texas versus Johnson. Here, this is a case involving the burning of an American flag at the Republican National Convention held in Texas in 1984. Mr. Johnson, who was an opponent of the policies and philosophy of Ronald Reagan, burned the American flag in Texas. He was arrested. Texas had a law that made it a crime to desecrate a, quote, venerated object, and flags were included in the list of venerated objects. Mr. Johnson's conviction was overturned by a Texas appellate court. The state of Texas then appealed to the United States Supreme Court, so the case is styled Texas versus Johnson. The state lost, and now it's asking the Supreme Court to reinstate the trial court conviction. But the Supreme Court upholds the Texas appellate court, and Justice Brennan's opinion holds that no state can simply make something a venerated object to prevent people from engaging in expressive conduct. So Justice Brennan is saying, if people didn't like one particular thing, well, you can't now define it as a venerated object to keep people from using expressive conduct to express their disagreement. A key part of the case for our class here on the topic of fighting words is an argument that the state of Texas made. The Texas Attorney General said the law existed to prevent breaches of the peace, as in people getting punched in the nose for their expression. So not only was the law intended to protect venerated objects, it was also intended to protect people from violence. But Justice Brennan's opinion noted that there were no breaches of the peace at the time the flag was burned, so the conduct wasn't sufficient to get people to punch anybody. And so in Cohen and Johnson, we see that the courts have not now found a set of facts to support the idea behind the fighting words doctrine. If we were in a classroom together, I would do as I do with all of my in-class law classes, which is to ask students if they can think of a fighting word. Now, when I do so, I am clear to explain that the test of fighting words is violence, and the test of violence is based upon the reasonable person. Will a reasonable person punch somebody at hearing the, quote, fighting word? Now, I know and you know that you can be in a bar and you can just say, excuse me, and somebody can punch you in the nose. I mean, you don't even have to say anything. You can look at somebody's girlfriend or boyfriend and they will punch you in the nose. So the person who's drunk and angry in a bar is not the test of fighting words. It is a reasonable person. So would a reasonable person at hearing a proposed fighting word punch you in the nose. And over the years, we have not found one. And we have looked at pretty much every term you can use to describe persons of different races, different ethnicities, different national origins, gender, sexual orientation. There is no word that we've found in all the years I've been teaching that constitutes a fighting word. So, as I say, it's an evolutionary dead end. It is a dinosaur or a dodo. But in these cases, the Cohen case and the Johnson case, the Supreme Court never has come out and said, well, fighting words is a bad idea and we repudiate it. So it's still lying there in some dusty closet waiting to be cleaned off and brought out for use again in the courts. Who knows? In the Trump presidency, we may see the creation or recognition of some fighting word. But on the test, don't try to justify punishment on the grounds that some expression constitutes fighting words. That will be incredibly wrong. There. Fighting words is an evolutionary dead end. And of course, you see on the screen what I would say to my class. And again, here, you can't use a hypersensitive person to judge whether or not something is a fighting word. So, the cases are in the book, fighting words is in the book, because this textbook you're reading is sometimes used in law schools, and law school students need to go through a lot more material than we would do. Let's move on to incitement. Incitement is defined as words directed and intended to cause listeners to commit specific criminal acts and that are likely to produce the violent acts urged by the speaker. So, key elements of incitement are expression, as in words, intent. There's where a lot of incitement cases fall apart because it is difficult to show the intent of the speaker to cause listeners to commit specific criminal acts, and then the likelihood of production of the violent acts. Let's start with some of the early cases, Soldier of Fortune cases. Soldier of Fortune was a magazine that sprang up in the 1970s. It was popular in the 1980s during the Reagan administration. It was filled with stories about people who were off fighting the terrible Soviets, freedom fighters in Afghanistan and in Africa. It was read in large measure by people still living in their mom's basement who had rich imaginations. There were stories about this is the favorite handgun, this is the favorite semi-automatic weapon, this is how to kill people with a knife or a coat hanger or a nail file. But Soldier of Fortune had classified ads. And in the Eyman case, John Wayne Hearn took out a classified ad in Soldier of Fortune, and the ad read, Vietnam vet, weapons specialist trained in jungle warfare. So John Wayne Hearn placed the ad in the magazine. He was contacted by Robert Black, who said, so you're a weapons expert, you're a vet, I will pay you money to kill my wife. And John Wayne Hearn said, sure. So Robert Black paid him. John Wayne Hearn killed Robert Black's wife, Sandra. Her maiden name was Eyman. Of course, the police arrested Mr. Hearn and Mr. Black. They were both convicted. Mrs. Black's family, the Eyman family, sued Soldier of Fortune. Now, the Soldier of Fortune case resulted in a judgment for the Eyman family against Soldier of Fortune, but that judgment was overturned by the Fifth Circuit Court of Appeals, who said that the ad, look at the ad there, Vietnam vet, weapons expert, is not provocative. There's nothing there that suggests that the person taking out the ad is willing to kill for money. And so they overturned the judgment. Soldier of Fortune skates. But then we had Braun versus Soldier of Fortune. In Braun, the ad was gun for hire. Professional mercenary, desires jobs, discreet private, all jobs considered. In Braun, you had a fellow who was in business with a partner. The partner decided to dissolve the partnership, but rather than buying out his partner, he hired somebody to kill him. The partner was killed. The partner's family then sued Soldier of Fortune, and in that case, the 11th Circuit Court of Appeal upheld the judgment of the trial court. The Braun family won in the trial court, saying the ad was explicit in its content and that the publishers, here Soldier of Fortune magazine, would have liability for publishing ads that exposed the public to substantial danger. So let's go back here. There you see the 5th Circuit. The advertisement was innocuously worded. The magazine would have no reason to suspect the ad would lead to murder. So there, John Wayne Hearn, Richard Savage. So here, the nature of the words creates the danger, and the publisher of the words therefore has liability. And the 11th Circuit, looking at the case, says the publisher should recognize the offer of criminal activity just as the readers did. Then we had Rice versus Paladin Enterprises. Paladin Enterprises publishes books which it sells at gun shows, many of them purchased by people living in their parents' basements who have rich imaginations. One book is called Hitman, a technical manual for independent contractors. The other one is How to Make a Disposable Silencer. And here you see language excerpted from Hitman, the manual, where they talk about Rex Farrell, the person who kills for hire. As you read the lurid prose, you'll see that this is creating an image of a fellow who is decisive, takes action, and is, in the minds of some, respected. So, James Perry buys both Hitman and How to Make a Disposable Silencer. He goes into the business of killing people for money. He's hired by Lawrence Horn. Lawrence Horn used to be married to Mildred, and he was the father of Trevor Horn. Trevor Horn was involved in an accident that left him paralyzed. He required around-the-clock nursing help. There was a lawsuit, and Trevor Horn received a substantial settlement that would pay for his care for the rest of his life. Janice Saunders was the nurse who was taking care of Trevor. So Lawrence Horn divorces his wife Mildred, and then he's living by himself, and the bachelor life isn't great. He doesn't have a whole lot of money, and he thinks, well, if my son dies, I will get his settlement and I'll be set for life because I'll have all this dough. So he asks around and finds James Perry, who of course has decided to go into the contract killing business, and says, I want you to kill my wife and my son. If you just kill my son, the money goes to my wife, so you have to kill both my son and my wife. They agree on a deal. Mr. Horn gives James Perry a map of the house, a key. James Perry follows the instructions, goes to the home, enters the home, kills Mildred, Trevor, and Janice Saunders, the nurse. He tries to make it look like it was a home invasion gone horribly wrong. He makes his escape, but he's not particularly good at hiding the crime. And so the police arrest him. They arrest Lawrence Horn. They convict him both for murder. Mildred Horn's maiden name was Rice. So she was originally Mildred Rice.